Welcome to NIPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nipt.com/law to read the full decision.
People v. Leighton R. Decided on November 25, 2025. Canataro J. The primary issue on this appeal is the standard that must be applied to determine whether police have reasonable suspicion to conduct an automobile stop based upon a contemporaneous report from an anonymous 911 caller that they were the victim of a crime. We hold that whether such a stop is justified should be evaluated under the totality of the circumstances. Moreover, since there was record support for the affirmed finding of both reasonable suspicion for the stop of defendant's vehicle and probable cause to search the locked glove compartment, the appellate division order should be affirmed. On June 7, 2014, an anonymous individual called 911 and reported that somebody just shot at me, resulting in a wound to his right arm. He gave his location as East 233rd Street and White Plains Road in the Bronx, and described the perpetrators as two black males in a white Mercedes-Benz. The caller also provided the address of one of the perpetrators. In response to further questioning, the caller advised the 911 operator that the perpetrators were people he knew and had beef with. He told the 911 operator that his name was Brian and stated that he did not know his callback number because it was a new phone. He declined the 911 operator's offers to send an ambulance or police assistance. The police dispatcher then broadcasted the report of shots fired at East 233rd and White Plains Road. An officer posted at that location immediately responded, "There's no shots fired over here." The dispatcher responded, "A male caller states he was shot. He was hit in his arm." The dispatcher also provided the description of the alleged shooters and vehicle over the radio. The dispatcher then attempted to call the 911 caller back, but was initially unable to reach the victim. Meanwhile, Officer Bennett Shelley, who was patrolling with his partner in a marked car about 4 blocks away, headed toward the location of the reported shooting. Within 30 seconds to a minute of the broadcast, Officer Shelley observed a white Mercedes matching the description of the shooter's vehicle and its occupants coming from the direction of the reported shooting. Officer Shelley executed a stop of defendant's vehicle, during which he asked to see defendant's driver's license and inquired as to where defendant was coming from. Defendant provided his license and stated that he was coming from a baby shower in Mount Vernon. During the stop, Officer Shelley asked the dispatcher for the location information for the 911 caller, and she confirmed, based on cell tower location, that the 911 call had been made near the area of East 233rd and White Plains Road. The dispatcher contacted the 911 caller, who again provided the perpetrator's home address, including apartment number, permitting Officer Shelley to verify that the address on defendant's driver's license matched that given by the caller. The caller also advised that the alleged shooting had not taken place in the Bronx, but in Mount Vernon. The caller indicated to the dispatcher that he was going to a local hospital for treatment. When asked by Officer Shelley if there was anything in the car the officers should know about, defendant responded, "No, you can check the car." During the search, Officer Shelley pulled on the handle of the locked glove compartment and was able to see a handgun and smell gunpowder through a gap. He then unlocked the glove compartment using defendant's key fob, found a handgun and ammunition, and placed defendant under arrest. The police were never able to locate the 911 caller. Following a hearing at which Officer Shelley was the sole witness, Supreme Court denied defendant's motion to suppress the gun. The court found that the proximity of defendant's vehicle to the alleged shooting within moments of the 911 call and the officer's observations corroborating the description of the suspects given by the caller provided reasonable suspicion to stop the vehicle. The court further concluded that defendant voluntarily consented to the search of the vehicle and that, once the officer was able to see the firearm and smell gunpowder, there was probable cause to search the glove compartment under the automobile exception. Defendant was convicted, upon his guilty plea, of attempted criminal possession of a weapon in the second degree. The appellate division affirmed, finding that suppression was properly denied, as the anonymous tip was sufficiently corroborated to provide reasonable suspicion for the vehicle stop, and defendant consented to a search of the vehicle, which led to probable cause to open the locked glove compartment. A judge of this court granted defendant leave to appeal. We have historically been skeptical of authorizing police action on the basis of an anonymous tip. In People v. DeBoer, we characterized the use of anonymous information to justify intrusive police action as highly dangerous, and observed that tips from unknown informants are of the weakest sort, since no one can be held accountable if the information is in fact false, and there is no way to assure, by way of intangibles such as voice, facial expression, or emotional state, that the information was communicated and received accurately and was believable. In recognition of the risks presented by anonymous reports of criminal activity, we have evaluated an anonymous informant's reliability and basis of knowledge under the Aguilar-Spinelli framework, see Aguilar v. Texas, Spinelli v. United States, to determine whether a tip provides probable cause, see People v. Grimminger. Where an informant has not revealed their basis of knowledge, as for example by personal observation, it is not enough that a number, even a large number, of details of non-criminal activity supplied by the informer be confirmed. Probable cause for such an arrest or search will have been demonstrated only when there has been confirmation of sufficient details suggestive of or directly related to the criminal activity informed about, to make reasonable the conclusion that the informer has not simply passed along rumor or is not involved, whether purposefully or as a dupe, in an effort to frame the person informed against. People v. Elwell. By contrast, the reliability prong can be established either by past instances of the individual's reliability or by independent observation of corroborative details by the police that are non-criminal in nature. People v. DeFalco. We have continued to apply the principles of Aguilar-Spinelli in the probable cause context even after the United States Supreme Court abandoned it in favor of the totality of the circumstances approach, see Illinois v. Gates, limiting the reliability and basis of knowledge prongs of Aguilar-Spinelli to relevant considerations in the totality of the circumstances analysis that traditionally has guided probable cause determinations, in recognition that Aguilar-Spinelli is more protective of our citizens' rights under the state constitution. See Grimminger, People v. Johnson. At issue here, however, is whether that same analysis is required for the lesser intrusion of an investigatory stop requiring reasonable suspicion. For its part, the Supreme Court in Alabama v. White applied the Gates totality of the circumstances test to determine whether an anonymous tip can support a stop based on reasonable suspicion. Our precedent is somewhat more unsettled. For example, in People v. Moore, we concluded that an anonymous tip cannot provide reasonable suspicion to justify a seizure except where that tip contains predictive information, such as information suggestive of criminal behavior, so that the police can test the reliability of the tip, citing Florida v. J.L. And in People v. William II, we held that anonymous tips that provided only readily observable characteristics and lacked predictive information that would permit the police to test the caller's knowledge were insufficient to establish reasonable suspicion. Those decisions followed the Supreme Court's decision in Florida v. JL, which emphasized the importance of predictive information as a means for police to test a tipster's knowledge and credibility. Significantly, neither Moore nor William II referenced Aguilar-Spinelli in determining that the respective tips did not provide reasonable suspicion for the stops. More recently, in People v. Argyris, we held that reasonable suspicion was established by a 911 call from an anonymous individual and the confirmatory observations by the police of information provided by the caller that was non-criminal in nature. Although there were multiple writings in Argyris, the brief majority opinion in that case, holding that the police had reasonable suspicion to stop the defendant's vehicle based on the tip, also stated that the absence of predictive information in the tip was not fatal to its reliability, citing Moore. On this point, the majority cited to Navarrete v. California, a Supreme Court case decided the same year, in which the Supreme Court appeared to retreat from JL's emphasis on predictive information, at least in the context of 911 calls reporting drunk driving. Navarrete held that an anonymous 911 call was sufficiently reliable to justify a traffic stop where the caller reported that another vehicle had run her off the road and provided a description of the vehicle, including its license plate, as well as the vehicle's approximate location and direction of travel. The court reasoned that, by reporting a specific vehicle, the caller necessarily claimed eyewitness knowledge of the alleged dangerous driving. That basis of knowledge lends significant support to the tip's reliability. As further indicia of reliability, the court emphasized the report's contemporaneous nature and the 911 system's capacity to identify and locate callers. In our most recent cases addressing whether there was reasonable suspicion to stop a vehicle based on an anonymous tip, we have been presented with fact patterns under which the result would have been the same whether we evaluated the reliability of the anonymous tip under the totality of the circumstances or applied the Aguilar-Spinelli framework. See People v. Walls, Argyris. We retreated somewhat from the requirement of predictive information emphasized in Moore and William II, stating in Argyris that such information was not required under the circumstances of that case. To the extent that there is an open issue as to which test should be applied when assessing reasonable suspicion as opposed to probable cause, see People v. Chase, People v. Landy, we now hold that the appropriate test is whether an anonymous tip is sufficiently reliable to provide reasonable suspicion under the totality of the circumstances. While this approach involves an analysis of the Aguilar-Spinelli reliability and basis of knowledge factors, allowance must be made in applying them for the lesser showing required to meet the reasonable suspicion standard. White. Here, the totality of the circumstances establishes that there was reasonable suspicion to stop defendant's vehicle. The anonymous informant used the 911 system to report that he had just been shot, necessarily claiming personal knowledge of the crime. The caller also provided a description of the alleged shooter, the make and color of the shooter's vehicle, and his location. The police were able to corroborate that information within 1 minute of receiving the dispatch and within a block from the reported location when they observed a car and suspect matching the description provided. The contemporaneous nature of the report is substantial here and weighs in favor of the caller's veracity. The police were duty-bound to investigate the radio report of a shooting, and they could not ignore their own contemporaneous observation of a vehicle matching the caller's description and location. Nor was the duty to investigate extinguished when another police officer failed to hear gunshots at the reported location. See People v. Benjamin. And although the police learned information that arguably called aspects of the anonymous caller's reliability into question as the investigation continued, our review of the reasonableness of the officer's conduct is limited to the information known to the police at the time of the vehicle stop. Had they been aware that the alleged shooting happened in Mount Vernon prior to making the stop, for instance, the result here might be different. Under the circumstances presented, however, there is record support for the affirmed finding of reasonable suspicion. Finally, there is record support for the affirmed finding of probable cause to search the glove compartment. See People v. McCrae. The courts below found that defendant consented to a search of the vehicle by offering to let the officer check the car. Even if defendant may not have reasonably expected that his consent extended to the locked glove compartment, see People v. Gomez, Florida v. Gemino, once the officer observed the gun and smelled gunpowder through a gap in the glove compartment, probable cause was established, and the officer could search the locked container under both the Fourth Amendment and the automobile exception to the warrant requirement. See People v. Ellis. Accordingly, the order of the appellate division should be affirmed. Order affirmed. Opinion by Judge Canataro. Judges Garcia, Singas, Troutman, and Halligan concur. Judge Rivera dissents in an opinion, in which Chief Judge Wilson concurs. Decided, November 25, 2025.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.